reminders as we start here. The webinar is considered to be informational purposes only. Immigration is obviously very fact-specific and changing very quickly. If you have any specific questions about a case or your immigration program in your company, feel free to reach out to Matt or myself. We'll have our contact information at the end of the slide deck. You can also navigate to our website, meltzerhellrung.com, and fill out a contact us, and we'll respond to you within 24 hours to set up a consultation. We've set aside about an hour today to discuss the topic. This deck's a little short, so Matt and I are going to riff here and there. We really encourage everybody, if you have questions, please type them into the Q&A function of the webinar, and we'll just try to address those in real time or answer them after we're finished. If it's too specific, we'll probably, unfortunately, we won't respond, or perhaps we'll respond via email after the webinar is over today. A reminder again that the webinar is recorded as well as the deck, so we'll send these out to everybody that's registered after the call or after the webinar today. So sit back, relax, try to learn a few things, and we'll go ahead and get started. So a little bit about us. Meltzer Hellrung, we combine an innovative service model, proprietary technology, and Voyager, and a creative immigration team to solve corporate immigration problems and programs for businesses inside the United States and around the world. We have over 200 active corporate clients at any given time, and a cross-section of that book of business looks like Global 200 companies, Fortune 500 companies in insurance, venture-backed unicorns in SaaS, AI, EdTech, etc. And we're really proud to have been named, ranked by the Illinois Chamber's Spotlight in 2025 guide, recognized for being a top law firm handling high-quality work in immigration. A little bit about our service model. We really pride ourselves on not only being great creative attorneys at Meltzer Hellrung, but solving the business problem that is immigration. And these are our SLAs to all of our clients. We are very responsiveness is one of our key client service components. How do we measure that? We have a 4.5-hour average response time via email. Efficiency is one of our core client service components. We turn around those transfer cases to get new employees on in 10 business days. We are extremely feedback focused. For every case that we file for a corporate or individual client, we ask for feedback from HR and the individual. We tally that together into what's known as an NPS score, or Net Promoter Score. Our Net Promoter Score in 2025 to date is, I believe, 92. And for those that don't know Net Promoter Scores, anything over 70 is considered to be best in class. And we pride ourselves in not only filing cases for clients and managing your foreign national communication and expectations, but managing your program specifically. And what does this mean for our corporate clients? It's a dedicated account team that consists of a dedicated partner, a dedicated account attorney, and a dedicated account paralegal. That is your 3-person team, building institutional knowledge of your business, managing all of your cases day to day, communicating via regular touch points, depending on the size of your program and your desired cadence, as well as immigration reporting and budgeting, which is really important for starting extensions, projecting what your costs are going to be next year in your program. In 2022, we made the leap to try to improve the experience that employers and employees were having with our service by developing our own proprietary immigration management platform, Voyager. We have all of our clients on it today, about 30,000 plus profiles in the system, and Voyager does a lot of things. Next slide. It drives process efficiency, transparency, and it centralizes all of your immigration information for your program in one spot. Specifically, both HR or people ops and your employees and their families get dashboards that show what's going on with all of your cases. What are the actions that you need to complete next so we can keep moving your case along? When was your case shipped? When was it approved? Approval notices, petitions. You can even track the shipment to the USCIS if you wish for each case. We developed efficient workflow automations that cut case preparation timelines and speed up our ability to file cases faster for you all. We feel that the quicker we can file cases, especially with transfers, the quicker you can onboard folks and continue to drive value in your own business. Our most recent feature is an extensive immigration reporting function that predicts extensions, green cards, It also helps us issue spot if there are things like travel bans or other issues in immigration or changes that are affecting your program quickly. And then we have a comprehensive immigration knowledge center that's available to your employees as well as your people ops folks. And that's designed to provide up to date information on things like blogs and changes that are going on in immigration, but also deep dive stuff. What does an H-1B actually entail? I have an employee that has an E3. I don't know what that is. You can log on there and access our E3 collateral to get a quick overview. Obviously, you can always contact us as well, and we're happy to sit down and walk you through it. Presenters today, my name is Matthew Hellrung. You've been hearing me speak for the last few minutes. I specialize in scaling high growth, venture backed, and larger multinational company immigration programs through training, as well as stakeholder training and large client management. With me today is my business partner and co-founder, Matthew Meltzer. Matt?
Thanks, Matt. Happy to be here. I'm Matt Meltzer, one of the other partners at Meltzer Hellrung. I do a lot of different things, but I work often with scaling and entrepreneurial businesses, including businesses entering the U.S. market for the first time.
So we've set aside about 15 minutes today to go through the agenda. And as I mentioned before, we probably will have some time at the end. So if you have questions throughout the sections, feel free to ask them. We'll try to answer them in real time. We'll also save some time at the end here to ask any kind of nascent or unanswered questions throughout the presentation. We're going to start about, the agenda today is really to highlight the things that haven't changed in immigration. I know there is so much that's changing on the, I would say, the undocumented, the asylee, the parole side, deportation. We want to really highlight that business immigration hasn't really changed that much over the last 5 months to date. And we're going to talk about processing timelines, first of all, for employment-based cases and green cards, requests for evidence, perm audits, and I have here noir, but a notice of intent to revoke. FDNS site visits, which is the USCIS's enforcement arm, as well as I-9 audits done by ICE, and then prevailing wages, where they are now, where they may be going in the future for work visas and green cards. Matt, you want to take processing timelines?
Sure. I think that processing timelines, where we've seen as far as we've been pleasantly surprised that things have not changed dramatically. It's always a question of caution of like how long things may stay that way. Clearly, there are efforts at USCIS that are subject to DOGE, where people are getting there are layoffs and incentives to quit, and there are also return to work requirements that have changed working conditions for people at USCIS. But nonetheless, the overall processing times have been fairly steady. Average processing times for H-1B extensions, 4 to 6 months. On the NIV side, non-immigrant visas, so temporary work authorization, things like H-1Bs and Ls, we have seen the USCIS stay true to their promises on premium processing. So if you are willing to pay $2,805 for 15 business day processing, we haven't seen refunds on those. The government is, in fact, processing in that timeline. H-4 EADs, despite the fact that USCIS is no longer legally obligated to process H-4s and EADs together with the H-1Bs, we are seeing that where H-4s and H-1Bs are filed together, the H-4s are being processed at the same time. So when an H-1B is filed concurrently with an H-4 and the H-4 EAD, we're seeing all of those approvals come in one batch. We're not seeing H-4s being processed separately from H-1Bs. So for our national planning, that's a huge boost because it's a big headache if the H-4 is processed separately, because there can be a lapse in work authorization. So we're hoping that that's not a blip. That's something that's going to remain consistent, but we will certainly be tracking that closely. On times when H-4s and EADs are being processed separately, we're seeing processing time around 2 to 4 months. OPT is about 90 days. And just as a reminder, there is premium processing available on OPT now. EB2 and EB3 I-140s taking around 7 to 9 months. It's a little bit longer than we've seen at other points over time, but not outrageous by any means, and certainly premium processing again remains available there. On the AOS front, this has been sort of like pleasantly surprising to me. You have to take the USCIS processing times with a grain of salt because they are usually batch in everything in the AOS, like regardless of the basis of your filing for AOS. So, that you can get some wildly specific data that isn't necessarily particularly indicative of what's happening on an employment basis. But we're seeing 8 to 12 months, but sometimes it's occurring faster. We have not seen yet uniform requirements for people to show up for interviews. We have not yet seen trying to throw those kind of wrenches into the system where resources are being intentionally strained by making more people do unnecessary things. So, uh, you know, we don't know whether these are trends that will last, but as of right now, like AOS is looking the same as it did under the Biden administration. And lastly, like the N400 process, people applying for naturalization, those who are, um, have been on green cards and are applying for naturalization, the process is going very fast. These are adjudicated locally, so there's no centralized processing for N400s. They get shipped to the office that is closest to where the person lives who is applying. And there are dozens of offices throughout the US, so there is different processing time. But by and large, we're seeing people who have applications that are not complicated by a criminal record or anything else get processed in several months. I've had clients and get approved in 3 or 4 months. Um, One thing I would really encourage from an employer perspective is that as demonstrated by like the um, Ma- Mahmoud Khalil situation in New York, where a permanent resident got, pulled into detention over political statements. The best protection that anyone can have right now is citizenship. And I think from an employer perspective, uh, looking at your employees, seeing how can you support permanent residents to apply for citizenship is an investment in the stability of your workforce too. So if you are an employer that has a significant green card holder population, please talk to us. There are ways that it might be beneficial on both ends to try to support applying for more naturalization. And so that's sort of like a very high level of what we're seeing on the processing times across the board. Uh, is that what's been remarkable is that there has not been a significant change in processing time. Processing times on any administration fluctuate based on volume and allocation of resources, but so even in under a good faith administration, there's going to be processing time is going to go you know, change a couple months here and there over the years, but we have not seen any major shifts thus far, 6 months into the administration.
Matt, on that topic of applying for citizenship, what are the general requirements for that?
Yeah. So to apply for citizenship, a person needs to have generally been a green card holder for 5 years. If the person acquired permanent residency through marriage to a U.S. citizen, then the person needs to be a green card holder for 3 years. Generally, the person has to have been living inside the US for at least 50% of that time, and the person needs to have not taken a trip outside the US for more than 6 months during that time. Um, Outside of those things, it's generally about just good character and behavior. So the person needs to have not committed a crime of any severity. Again, something like, someone committed a crime like public urination is probably not going to be a barrier to getting citizenship. Um, so don't just say any crime is a problem. And then also to qualify, the person has to pass an English language test. So almost anyone who's in the employment-based categories for holding a visa in the past is going to qualify automatically. It's a very, very low level of English literacy, somewhere probably around like a first or second grade level of literacy. But certainly, if you are a manufacturing employer and you have other employees who may have green cards that are not people who are sponsored for visas, it might be a different so you're looking at something different in terms of their competency with the English language. And you have to pass a civics test. So the government has a bank of 100 different questions, and people who are applying have to answer. Will get 10 of those questions given to them if they answer six correctly.
Thanks, Matt. We have a question here. When filing an H-1B extension with an H-4 using premium processing, do you have to pay separately for each applicant? I assume premium processing, or is there just one fee for the entire like joint application? We'll call that.
Yeah, so there are no premium processing eligible for H4s and H4 EADs. As of right now, they're filed together. The USCIS will generally approve the H4 together with the H1B and give it the benefit of the same processing time.
Personally, I've heard some rumors of the EAD processing being a little faster as well, but as you know, that's not a necessarily requirement, nor would I would say bet on that in the long term. Labor certifications or perm processing timeline. So this is where kind of the flip of the script here. This is where we've seen processing timelines lengthen. I personally don't think this is a result of the Trump administration. The Department of Labor receives funding that's authorized by Congress. USCIS that adjudicates non-immigrant visas and EAD cards. They are fee funded. So there's a mechanism where they raise fees and then hire more folks so they can continue to process the volume of work they receive. The Department of Labor is not that way. They receive funding from Congress. They have a budget, and the Employment and Training Administration, specifically the sub department that processes perms, they have not received a lot of funding for additional Department of Labor officers to adjudicate things like prevailing wages and perms. So we're seeing right now a perm process is the first step in a three-step process to get a green card. It is, or it's also known as a labor certification. Perm is, I think, the system that we used to use as immigration attorneys. That's why we call it that. Um, the the first step of that process is a labor market test that you have to go through, and there are a bunch of requirements you have to fill out, including drafting a proper job description with education and hiring requirements. You have to make sure the employee that you wish to sponsor on the employment-based side, who's likely already on some type of visa, um, it must qualify for the position with experience that was gained prior, usually to joining the current employer that's sponsoring the green card. But after you get through that process, which can sometimes take a month or two, you file the prevailing wage request. And this is really the first form that's filed with the Department of Labor as part of the green card process. It includes the company, the attorney's name that's working on the case, the information for the job description, the location, the employer, and the Department of Labor looks at that and assigns a wage that's based off of a kind of a survey-based metric system. And when Matt, when we were young attorneys many years ago, I think I can remember prevailing wages taking something like 60 days, right? Sometimes even 30, maybe 10
You
plus
were a
years
young
ago.
attorney once?
Youngish, okay. Um, but 6 months is what we're seeing right now. So that's like a 3 or 4 fold increase. This has continued to get a little longer. Matt, what are your thoughts there?
Yeah, I mean, this is not related to anything to do with Trump. This got long under Biden. And the fundamental problem is that DOL doesn't charge anything for these. They're not authorized to charge anything for this process. And they're given a limited funds the by Congress for staffing this department. The Wage and Hour Division, OFLC is what it's called. And based on the number of applications incoming, and this unit handles both H2 applications and perm. Like there's way more demand than there is supply of like actual staff. So if this is something you want to see improved, I would say write to your congressman and tell them to go either allow the government to charge for this or send more money to the DOL, but it really has very little to do with anything related to Trump.
Yeah, I was looking at just like raw volume numbers preparing this deck today or yesterday, and I think something like 151,000 perms were filed in 2024. So you can imagine that's probably slightly more than that in terms of prevailing wages, because sometimes you get a prevailing wage determination that's a little out there, or the officer, we feel the officer made an incorrect decision. It's probably a little bit more than that. But 6 months is a long time. when it was taking 30 to 60 days, not that long ago, so maybe 7 to 10 years ago. Step two in that process, once you get the prevailing wage request back, is recruitment. That's required for all labor certification or perms. Now, you have a maximum period of 6 months to generally get recruitment done. We try to always get it done as quickly as possible because, as an immigration vendor for our clients, that is a timeline that we can control. We can't control how long the government takes to adjudicate, forms that we file, but we can speed along recruitment as quickly as possible. So our goal is always to complete that recruitment within 2 to 4 months. And again, this just varies depending on the immigration vendor you have. There's also ways to run batches of perms and prevailing wage requests and things like that that are a little bit more complicated for our larger volume clients. But generally, 2 to 4 months is how long recruitment's taking. Um, and honestly, it can't happen any faster than 2 months because the state job order has to be posted for 30 days, and there's a mandatory 30-day cooling off period. So really, like 62 days or 61 days is the absolute fastest it could ever go. Thereafter, we're working on preparing the actual perm. A lot of people don't know this, but all the job description, the prevailing wage information, the recruitment, the resumes that are received, and from folks from the labor market that are ultimately disqualified. That's all information that we keep as an immigration vendor for our clients, but we don't file any of that paperwork with the government. We put most of that information into a ETA 9089 or a perm application, and then file that with the government. That usually takes a few weeks to prepare, to make sure that all the resumes for folks that were submitted were properly disqualified and that you can actually sponsor your employee. This is the labor market test that we were talking about. Now, when we not even that long ago, maybe 5 years ago or so, perms were probably taken between like 6, maybe 8 months, 10 months on the long end. We have really seen a significant increase in perm processing timelines over the last I would say, since the pandemic. Right now, I put about 16 months. We're seeing anywhere between like 15 and 18 months. I'll say 16 months in the middle there. And as I mentioned, since the pandemic was typically about 6 to 8 months beforehand. Back to what Matt said before, limited resources, more people filing for green cards, just not enough folks, not enough hands really to look over these applications and adjudicate them in a timely manner. And I would expect, because of the way that immigration is going on the undocumented side, with parolees and asylees, being very anxious, I would expect more perms to be filed. So one of the ways to kind of get out of that situation, or secure yourself or establish a secondary form of immigration status or insurance, is to get a green card through as quickly as possible for the individual if they're eligible. And I would expect that these perm process timelines are going to increase throughout the Trump administration. Matt, your thoughts there?
Uh, I agree. And I think that I think that we have a question in the comments about a number of people applying to jobs, and I think that we're seeing that go up for some of our employers. So I think it's just really one of those things where you have to, we're constantly working with our clients to assess like what's the best strategy to advertise for perm, balancing a bunch of different kind of factors. And different depending on who you are as a company, you might be more or less attractive to apply to. But there's the question from in the comments asking about how many people might be too many. It really depends on how many people are applying and what they're applying for. We have some clients who have jobs where they require 3 years of experience, and they get 100 applicants from people who are currently in college. That's not too many because none of the people are qualified. It's not a problem. It's annoying, but it's not a problem. So I think I don't know if I answered your question, Matt, but that's sort of like one of the things we see on trends.
Yeah, I mean, I think this is where some good lawyering can help as well. There are 3 pieces of required recruitment that you must run as an employer. And then there's 3 pieces of what we call discretionary recruitment. That's a bit of a misnomer. You have to run 3 pieces. You just get an option of choosing 10 ways or 10 different ways to run those additional 3 pieces of recruitment. And some good lawyering and strategy can help you choose the pieces of discretionary recruitment that will be least likely to be seen, and therefore limit the amount of resumes that are received. But as Matt mentioned before, there is no minimum. You can, previous firms that I've worked at, when we've run certain types of positions, we've had hundreds of resumes submitted, and we've been able to disqualify all of them successfully. So it is a bit of a pain, and we want to lighten the load on employers having to look at those resumes. So we try to choose pieces of recruitment strategically. Um, but yeah, there's no minimum number. So overall, though, if you take the new, like, 6 months with the prevailing wage, maybe a month to get the job description together, 6 months for the prevailing wage, 3 months, 3 or 4 months for running recruitment, maybe a month to prepare the perm, and then 16 months thereafter to file the perm and have it adjudicated by the Department of Labor, you're looking at a pretty significant overall increase in the how much time the first step takes in the green card process for perm-based green cards. And we're talking to clients all the time about this because we're always looking at perm processing timelines. Why do you do this? Most people that we work with are on H-1Bs, and you must get to an I-140 approval, which is the second step of the green card process before the H-1B maxes out in 6 years. So you really have to time these perms properly. And we used to be able to get a perm done in like 12, 14 months. It's almost double that time now. So what does that mean for employers? You should really go back and look at what are your green card sponsorship policies. We draft immigration policies for all of our large clients. We maintain them. We review them regularly to make sure that they are benchmarked against competitors, that they are achieving the goals of the program that we've set up for our clients. But I would recommend looking at that. If I was HR, people ops, whether it's with us or your current counsel, look at your green card sponsorship policy right now. A lot of employers will say, we won't sponsor a green card until the person's been working for us for 3 years, or we won't sponsor a green card until the person's been here at least a year. With the extension of the perm processing timelines, and an I-140 thereafter can still take a few weeks or perhaps a few months, depending on whether you want to pay for premium processing or not. You're looking at like 30 months worth of time between when you start the green card and potentially when you'll get to that I-140 approval stage and remove that 6-year maximum for your H-1B employees. Also, simply like for Ls and other folks that are on other types of visas where there is no I-140, kind of caveat or exception to continually extending your H-1B, you might want to even start them sooner than that. So look at those green card policies, calculate the new perm processing timelines in, and you may need to change them. Maybe start them a little earlier. Matt, another way to, potentially combat the extension or the additional time that it takes to get through this perm-based green card process, there are other types of green cards that may be available to individuals.
Yeah,
Can you talk
and
about that?
there are several, and the ease of applying these for these sort of ebbs and flows, like as interest in these goes up because of the challenge of perm and the challenge of waiting for priority dates. Current higher interest in EB1s and NIWs goes up, but there are several categories that are exempt from the perm process. EB1s in a variety of categories. There's EB1s for people who have extraordinary ability, who can be extraordinary in just about anything. There are EB1s for multinational managers and executives. Regardless of whether or not you had an L1A previously, you could be a multinational manager or executive. So then you could be on H1B, and if you still qualify for an EB1C, if you meet the qualifications. There are EB1s for researchers, EB1Bs. The national interest waiver is about doing something that's quote unquote in the national interest. So, is there something about what you are doing that puts America in a better position that's really open to interpretation at a given time? And then there's the EB2 exceptional ability, which looks a little bit like an EB1, but it has to be employer sponsored, where EB1A extraordinary ability can be self-sponsored. EB2 exceptional ability has to be employer sponsored. There is a prevailing wage, but it is it's a lower standard of review than the EB1. So for most people, especially from India, they want to be in the EB1 category. But if the goal is for someone who's never gotten an I-140 before at all, and just to be able to extend H-1B, getting into any category is desirable.
I will, just to kind of example folks that we've applied for EB1A, athletes, artists, performers, entrepreneurs, research, the EB1B, you're looking at outstanding researchers. These are people that are typically PhDs or doing research inside of a research organization, medical doctors, perhaps, scientists. And then, as Matt mentioned, the EB1Cs are typically your multinational executives, folks that have been a manager abroad, but also a manager in the United States in some capacity. Matt, anything else on the green card, processing timelines you think is worth mentioning?
No,
Cool.
I think that's a good place to be.
Um, so requests, something that we saw in the first Trump administration, which we expected to see now, basically, which we really haven't thus far, are a significant increase in request for evidence. Request for evidence is you file your immigration application with the USCIS for an H-1B or an L or any other type of work visa or benefit, and the USCIS comes back with a request for evidence saying we need more information from you. Sometimes this is legitimate. Perhaps the narrative that was told in the visa application was not quite fully understandable by the visa officer, or there was a document missing for some reason or another. But the Trump administration kind of opened up a new way of using these, which was we're just going to blanket issue requests for evidence across all these visa categories to make it more expensive, to slow the process of these visa approvals down, and just to clog up the process in general. And that happened in the first Trump administration. Fingers crossed, knock on wood, we have not seen a massive amount of increase in RFEs. Now, this is somewhat anecdotal because the data does not come out for quite a while, but we're going off the couple thousand cases a year that we file as a firm, and we have not necessarily seen a significant increase in RFEs. A little bit here and there, some weird ones issued that we haven't quite seen before. But to give you a kind of an objective measure here, the RFE rate at the end of 2024, the last few months of the Biden administration, was roughly about 10%, or 1 in 10 visa applications got RFE'd. I think at the peak of the Trump administration, about 4 in 10, or about 40% of cases were receiving RFEs at that point. So fingers crossed that this trend continues. But we have not seen a significant increase in requests for RFEs. That doesn't mean that it won't happen going forward in the future. It just means that we're not seeing it right now. Matt, your thoughts there?
Yeah, I think that it's one of those things that we are sure to see an increase at some point in time. I think I think this is one of those things that is reflective of where the agencies and the government's priorities have been. They've dedicated so much human energy to people in non-business immigration related statuses. I mean, the amount of just like human brain power that is going to deal with, making life miserable for people who are on TPS and asylees and any number of things is a lot of real work. I'm not making light of it in any way, but I think that it also means that there's just limited bandwidth within the agency to make things a lot harder in some of these other business areas. So I think it's only time will come where things do get more difficult. But it right now it has not been that way.
Some my personal opinion here, or at least I'm hoping that if you take a look at the top 50 funded AI companies in the United States, most are venture backed in some degree. It's really the business model right now. Over half of them are have founders that are currently immigrants. If you go take a step back and like first generation immigrants, it's like 75% of the companies. So my hope is that if we want to really lead the world in this next disruptive technology, which is AI, you really have to understand that we have a lot of smart Americans, but we need the smartest people from around the world to be working on this stuff. And my hope is that they're starting to realize how important that is, especially on the top end. And this, the O's, the H's, the green card processes, the RFEs will hopefully stay where they're at. But we'll see how it happens. Notices of intent to revoke. Now, these are, we call those noirs as immigration attorneys. These are issued after visa applications have been approved. So you apply for H-1B in the lottery, gets approved, start your job, and something happens. The USCIS receives a complaint, maybe ICE does, or some other government agency, and communicates it to the USCIS, and all of a sudden you get a notice of intent to revoke after the visa application's been approved. We have not seen a significant amount of these issued, but where I have seen it in the book of clients that we have is they're doing a lot more FD&S visits, which are Fraud Detection and National Security Unit. This is like a quasi-enforcement agency inside the USCIS. Their job is to really, and we'll talk about this in the next slide, to check and make sure, do site visits, phone calls, emails, to make sure that the H-1B that you sponsored as a business, the L that you sponsored as a business, the individuals in that position at that location doing that job. There's not a lot of these because, again, as Matt mentioned, resources are limited. But I have seen in instances where you have site visits where perhaps the information provided or the employee answers don't necessarily match the application that's been on file with the USCIS. A slight rise in noirs in this area, and I would say. Personally, I think that we're seeing it most often in the IT consulting community. There was a new H-1B rule that was published by the Biden
Hmm.
administration just before they left office, and I think that they're using that a little bit to take or using that the new requirements of having, like, people have been in immigration for a long time, the MSAs, the statements of work, the letters, the client and client letters. I've seen that here and there. And Matt, what do you think?
Yeah, I agree, and I think it just emphasizes that, you know, there are more resources across the board going towards compliance at the agencies. Um, More resources are going to go to ICE through the upcoming budget. There's more resources going to FDNS. So it informs employers that they should be more buttoned up about compliance, and take their compliance efforts a little bit more seriously. This was not a huge issue under the Biden administration. There weren't huge numbers of site visits. There were, in terms of like I-9 audits, I think I heard last week there were 265 the entire time that Biden was in his office, which is crazy. Like less than one per, like, that's like, what, there's 48 months in a term. So there's something like, 10, 10, less than 10, 5 a month, something like that. It's like crazy low. Um, those numbers are going to rise. And they can yield the information that comes out of those investigations can come to other places like these notices of intent to revoke. So I think it just goes to informing like companies being more stable and sure-footed about compliance.
Yeah, we'll talk about that in the next slide. So, um, labor certifications, or perm
And
audits.
I'll take this one, Matt.
Yeah.
Li- we talked about labor certs. While the processing times are long, the most recent data, and I really don't see this as being informed by Trump at all. Q4, which is and Q1, 1.5% of perms are denied, super low. Um, Many more perms receive an audit. Keep in mind that the DOL audits a certain percentage of perms just randomly because there's nothing submitted with a perm to support the information put in the application. So they audit some of them just randomly to keep employers honest. Um, but there's no actually really good data that I'm aware of about where perm audit rates are. Like we at Meltzer Hellrung has see like maybe 1 in 10 or less of uh, perms being audited. Some of it is there are certain things that will trigger an audit, like if you say that there's an English language qualification or the company is owned by the same person, owned by a family member, the person being sponsored, like those are automatic audit triggers. But by and large, we're not seeing huge numbers of audits. And again, given the resource constraints of the office and how backlogged they already are, I don't see the DOL increasing the number of audits tremendously.
Yeah, the 1 in 4 audits. I pulled that from a trusted data source. I was a little surprised that it was actually that high. Um, I think that has to do a lot with companies filing their own perms, or we'll call it general practitioners who are working on perms that are not seasoned immigration attorneys making. Um, they don't know what they don't know. That's why all attorneys, I think, have specialties in specific area, because there's all these little minute rules and decisions and um, cases and precedents with agencies that it really does take it's like a seasoned practitioner to really do things well in a lot of areas. Site visits. So as we mentioned before, we already talked about fraud detection and national security unit. This is the quasi enforcement arm in the USCIS. Very interestingly, Matt and I were at the American Immigration Lawyers Association conference last week, speaking with, like, getting ourselves, up to on the level with changing topics, and also speaking to a lot of other colleagues we have in the community. Matt, I don't know if you talked to this individual or not, but there is the USCIS's mandate is really to basically process paper and approve these visas. And there's a question, I think, whether the FDNS actually should be inside the USCIS as a quasi enforcement arm of an administrative agency, not an enforcement agency. So it's a novel legal argument there to see. I'm sure somebody will probably bring that forward if FDNS site visits, get out of control here over the next few years. But that said, FDNS, whenever you pay for your H-1B and your L fees, they've gone up in the last few years. Like, what the heck is the government doing with this money? That fraud fee that you pay with new H-1Bs and new Ls goes to this fraud detection and national security unit. These individuals, again, do site visits. They can call, they can email, they can show up in person sometimes. Really depends on where you lived. Sometimes it depends on how new the officer is. It can also depend on how old your immigration program is. If they know that you're running we have a large client in Wisconsin. They run a very, very compliant and honestly a exemplary program that we've helped work with them on. Their FDNS officer just sends them an email about something and says, "Hey, I want information on this person." And they email it back. Person never shows up in person because they have a good reputation with the FDNS unit in that area because they followed the rules for such a long time. And this goes to what Matt said earlier. Maintaining compliance, protecting your reputation with these government agencies can go a long way if you're consistent about it. But overall, we've seen a slight rise in FDNS visits. As Matt mentioned before, we will probably see more of them. I have personally seen them rise in the IT consulting community as a result of that H-1B rule that was published, placing greater restrictions on consulting companies that are locating folks at end client sites. Long story short here, at least with pertaining to FDNS, have a site visit plan in place. We work with clients on this all the time. Let's establish a point person. If you have the opportunity, like, allow them to request documents and say, we'll get those to you in 48 hours or an extension. Bring that information to your counsel so that we can look at it. FDNS is kind of like the tip of the spear in some ways, where if you have issues with FDNS and folks are not where they're supposed to be or not making the wages they're supposed to be, one, it can seep into the rest of your visas. You can start getting a lot of noirs from the USCIS. They can make a report to ICE, and all of a sudden you've got an ICE I-9 audit on your hands as well. So it's really important that, in any interaction you have with these agencies, one, be accurate and forthcoming as much as possible under the law, but you call outside counsel and let us walk you through this, because we see this a lot, and sometimes there's an ulterior motive behind some of these things. Now, you want to take immigration and customs enforcement?
Yep. So ICE, I think that from an employer perspective, this is certainly the area where you're most likely to see disruption. Uh, I think is ICE looking for H-1B workers? Is ICE looking for L-1 workers? The answer is no. ICE is looking specifically for unauthorized workers. Again, Matt and I were at the American Immigration Lawyers Association conference in Denver last week, and ICE audits are up, ICE visits are up, but it seems that anecdotally, ICE is really not looking for paperwork errors. They're looking for unauthorized workers. So from an employer perspective on this, be aware of that if you are hosting unauthorized workers, and I can't imagine as many of you who are coming to a Meltzer Hellrung webinar who are in that pool, but should someone be in that pool, um, I would encourage you to reach out to an attorney sooner than later. It's a huge risk, and the government is looking for holding employers and individuals, leaders at employers, responsible for hiring unauthorized workers on a criminal basis. The sort of cutoff that they're looking at is 15 unauthorized workers. But if you are knowingly hiring or deceptively hiring unauthorized workers, 15 or more of them, criminal liability, not just civil liability, could attach. But I think that, so from an I-9 perspective, I-9s are getting more complicated as the government changes status on people, changes TPS policies, changes humanitarian parole policies, is giving new notifications left and right. I think it's a really important time to just be aware of what your I-9 processes are, who's owning that process inside the company, what is the review process, what is how are I-9s re-verified. My biggest advice is that if you have blue collar workers in any significant number at your company, I really encourage you at first to start with your own audit, but I encourage you to reach out to an attorney, whether it's Meltzer Hellrung or another one.
Yeah, we're doing an audit for a client right now that's in the food processing industry, and what we do there is one, we look at everything, all the I-9s, the payroll records to make sure that everybody's properly employed and verified. But two, sometimes things look so suspicious, and I think what we can offer an employer is, if you do receive an audit, what percentage of your workforce, let's say out of 1,000, how many of these folks are potentially vulnerable to uh, a re-verification in which they can't provide valid documents or perhaps a subsequent ICE raid on the facility. It's good to kind of understand your liability and exposure there. Again, there's not a lot we can do to fix the I-9s or fraudulent documents of folks that are undocumented, but to give you knowledge of how your workforce may be affected as part of an ICE audit and subsequent raid is definitely information that a lot of our employers find useful. Matt, there's an interesting question here from an honest attendee that's reported that anti-immigration groups are using AI to submit lots of applications uh, to job advertisements during the perm process to like flood the job postings. Have you heard anything about that?
I haven't. Um, Again, it might be something that's being more targeted by at certain companies. Again, I think that the size of your company and the nature of the organization is going to change it a lot. Like a company with 100 employees overall is probably not getting spammed. Company that, if you're a Fortune 100 employer, can I imagine that happening a lot easier? Honestly, yes. Very few things would surprise me. But at the same time, it should also, uh, you know, should not make employers not go do things. Like the same AI that can spam things should also be able to review and reach out to for people to verify whether or not they're real. If someone responds and the employer has to reach out and say, are you actually interested in this job? Are you qualified? If the person isn't real, then there's no actual problem with the perm. A resume doesn't disqualify the perm process.
Yeah. I think something I have seen, and I think this is unrelated to that question, but also it affects the perm process. You have a lot of, the job market for students coming out of school is the worst that it's been in a very long time. Um, Part of this is just the nature of how the economy is structured, but I also think part of it is that AI is really doing a lot of the low level, maybe white collar jobs that college graduates would normally do. And we have seen an uptick in the number of applications being submitted to perm jobs, but mostly by entry level folks that are, as Matt mentioned, are still in school. So that could also be part of this as well. Um, so another bright spot to highlight here: prevailing wages. So most people are not aware, but the Department of Labor sets prevailing wages for a lot of different visa categories, including green cards. Why do they do this? They want to make sure that foreign labor does not flood the U.S. market and undercut U.S. wages. And I will tell you that in a lot of cases, especially in more rural or kind of secondary cities, the wages that are required for these visas are often more than what they're paying U.S. citizens in the first place. Um, so I kind of want to dispel a bit of a rumor there that I think that immigrant H-1Bs and E-3s are just cheap immigrant labor, and oftentimes we are having to ask the HR to raise the wage to meet the minimum required wage, and they come back to us and say, "Well, we don't pay anybody that wage in that position here." So dispel that rumor right there. Um, so the wages are set by the Department of Labor. They are survey based. They send thousands of survey out every year to all areas of the country uh, concerning all different hundreds of different types of jobs and subcategories of jobs that are in the database. Right now, there has been um, some rumors are rumbling that they may change the way that they do the wage methodology in the future. But a bright spot for 25 from basically July 2025 to June 2026 is that there will be following the same methodology. Now, there's always going to be generally a slight increase in wages, especially with inflation right now, as people want raises greater than the rate of inflation. So you might see the surveys come back with folks with higher wages. But generally, we're going to see a slight increase in wage as we would expect under the same methodology they're using right now. Now, that's not to be said that 2026, 2027 year, when they release those wages in a year from now, they may update the wage methodology, submit a new rule, or calculate it a different way. Now, certainly if it's outside the bounds, or I would say probably just generally You can always probably sue to injunct that if they feel like they haven't followed the rules. But right now, bright spot is that they're not really significantly changing the way they're calculating wages.
And Matt, I would just add one thing to this.
Mhm.
Wages for DOL, as you noted, are on a July 1st to June 30th timeline. We do not know what the wages will be in advance of July 1st. So we are 6 days away from wages changing.
Mhm.
But for H-1B purposes, if you are an employer where you're on the precipice, of feeling like the wages are high, you can lock in wages. An LCA is good for 3 years, regardless of when it's filed. So you can file an LCA for, as of today, for a 6 months out. So you can file an LCA for December 25th, 2025 through December 25th, 2028. That will be valid based on today's wages. So if you are an employer who is concerned about potential wage changes and wanting to lock in rates today, you can do so. It will inherently not give you LCAs that are valid indefinitely, but it can be a really useful tool for riding out potential uncertainty if you think that there, especially if you're in a low employment area where the you know um, the survey data is unreliable.
Yeah, I would add 2 points to that, and I think that's a great point that Matt made. One, you can file an LCA for multiple employees as well. So you can file. I don't know what the top end, Matt, is. I've never had to do it, but
I
I
have
think
no idea.
100.
I've never done it for more than like 20, but I don't know if
Yeah,
there is an upper limit.
I don't. I mean, logically, I don't think there is. So you could file a one LCA for, let's say, your software developer position in Detroit, Michigan. 6 months in advance to lock in wages for 1,000 people. Now they all have to be in that position and have that job description. But as Matt said, it's a good way to lock in wages. You can do the same thing with prevailing wages for green cards as well. So there's the opportunity. There's always, as Matt mentioned with the AI comment, there's move and counter move here. This is a cat and mouse game at all times. Just important to have creative counsel who thinks about these things, trying to save your company some money. Um, uh, Anything else on wages here, Matt? Oh, the other thing I wanted to mention was, if the wages do get out of control, there is the opportunity to submit an outside wage survey. These
Yep.
are published and used by HR teams around the country to adjust compensation levels and everything. Now, they have to meet specific requirements the Department of Labor has, but you could use something off the shelf. Like Mercer was one that we used to use quite a bit back in the day. It has to meet certain requirements and have enough specificity. But there is, again, move counter move here. Is wages that the Department of Labor is publishing are getting outrageous for their new methodology. The idea would be that we switch to wage surveys to bring those back down. Um, oh, and the other thing too, I just would mention, it's counterintuitive. We all want folks to get to permanent residency quickly. It does cut off the overall cost of H-1B extensions and extensions of other visas. Sort of lessening the lifetime spend per immigrant employee that you have in your organization. But a bright spot generally is that because perms are taking, so perms and I-140s and then adjustment of status, that three-step process are taking so long. Right now, I would put it out if you start a perm right now in a non-backlogged category, which many are at the moment, and that person pushes all the way through one application perm after I-140 after AOS, that's probably going to take 3 or 3.5 years for that, maybe four, for that individual to ultimately receive their green card. Now, the good thing about that is when you set a wage at the beginning of the green card stages 3 or 4 years ago, so you have some time as an employer to work the wage up for that employee because you don't have to pay that prevailing wage for the green card until the employee physically receives that green card in their hand 3 or 4 years from now. Same with the H-1B. You don't have to pay the individual the increased wage until the LCA is effective for that new H-1B extension or initial H-1B application. So that's the end of our presentation today. Some really good questions. We really appreciate everyone. If you everyone listening today, as I mentioned before, the webinar is recorded. We'll be sending out a recording of it as well as the deck that we're using. You saw our contact information there at the end of the slides. Feel free if you want to. Feel free to navigate to our website. There's a lot of information about this on our website, and you can fill out a contact us form, and we will be happy to schedule an immigration consultation with you. We appreciate everybody's time and attention today, and hope everybody's staying cool with the heat wave in the country. And I don't think we'll speak beforehand, but have a wonderful 4th of July. Thank you, everybody.
Thank you. Bye-bye.